This podcast is brought to you by Bloomberg Law. For more information about our professional services for the legal industry, please call 212-617-6569.
You're listening to Bloomberg Law. I'm Josh Block. Proposals for new top-level domain names were revealed today. That's the .com part of an internet address. This is the largest ever expansion of the internet's naming system. 1,410 new suffixes were proposed. Applicants paid $185,000 for each proposed domain. John Murino is an attorney at Crowell and Moring. His practice includes advising both internet registry service providers and corporations applying for top-level domains. He joins me now. To many, the expansion of top-level domain names is much ado about nothing. Won't people still find the websites they're looking for through a search engine?
Only time will tell how big of a deal it will ultimately turn out to be, and in part it will depend on what the applicants and the corporations choose to do with their TLDs. But at the very least, it's a big deal because this is an evolution in the architecture of the Internet, certainly, and it will provide avenues for entrepreneurs and corporations to sort of take their Internet presence in a new direction.
Some companies like Apple and Sony applied to defend their brand names. Other organizations are looking to start businesses registering websites in a given generic space, .book or .music, for example. Tell me about the various reasons that organizations submitted applications for new top-level domain names.
Some existing large brand corporations applied to protect their name in this new space. Some of them are deciding to apply because they want to do new and interesting things with their business and their new Internet presence. And there are some entrepreneurs out there who are looking to start a new business by applying for a generic name and selling that space.
Today, the actual list of domain names was revealed. What did we learn from it?
What we learned is that there are some big players who have applied for tens of names, both names that have to do with their own brands and trademarks and generic top-level domains, so generic words that may impact an industry that they're in or an industry that they're considering.
Amazon filed 76 applications and Google filed 100. They have a lot of overlap, .movie, .book, .music, .cloud. What do we know about their strategies?
I don't know that we know a lot about what their strategies are just yet. We are going to learn about their strategies in the weeks ahead. Some commentators have already noted, though, that some of the applications seem to imply that they'll be looking to adopt a closed space, which is to say, if they're applying for a .app, they're looking to keep the .app and the second-level names that will come along with that in their own organization. But they're not looking to sell them necessarily to third parties.
Are there still cyber squatting concerns?
There are cyber squatting concerns, and I think that there will be cyber squatting concerns for some time to come. ICANN is aware of these concerns, and so they have built into the process ways to combat cyber squatting at the top level and at the second level. What I mean is to the right of the .com, if you will, that's the top level. When it comes to the second level, so that is the cyber squatting disputes that you see between if someone attempts to register a popular brand name in .com, those are going to exist again because there's simply more opportunities for people to register names because there will be more strings available.
Part of the application process was to weed out entities that might allow cyber squatting.
Certainly, part of the application process was aimed to prevent those types of corporations from applying. So ICANN, in part of its evaluation, will review the applicant and the string, or the letters. So as far as applicant goes, they'll be looking into doing background checks of the applicants to see have these corporations been involved in cyber squatting in the past? Do they have any judgments against them? Those types of things.
If you're a lawyer practicing in this area, what are you doing today? What are you doing in the coming months?
The lawyers are going to be paying attention to this list to see where their clients' business will be impacted or have been impacted. And it can be impacted in more than one way. So the lawyers were having conversations with their clients before the application round to say, is this something that you want to pursue for business reasons, or are there other reasons that you might want to apply? And a corporation made a determination before May 30th, do they want to apply or not? And so that's over. But now corporations who maybe decided they didn't want to apply, they didn't want to get involved, they were happy with their existing domain portfolio and they couldn't convince people within their corporations that this was a risk worth taking. Now they have to be concerned whether someone else applied for a string that may impact their business in some tangential way. So it wouldn't necessarily be someone else applied for a trademark that they have as registered, although they may. It may be that someone applies for a generic name that impacts the industry in which they participate.
So what is the process now for those lawyers that find that there is someone trying to register a name that they didn't apply for but have interest in?
So at first, there'll be a determination whether the applications are handled in the first batch, second batch, or subsequent batches. And once that's determined, there will be evaluations of the existing applications. During that time, ICANN is running concurrently a public comment period. So an applicant or a non-applicant can write a comment about a pending application. After the comment period closes, there's also an objection time period where members of the public, other applicants, can lodge objections based on certain enumerated criteria, and then those objections are dealt with by certain dispute resolution providers.
There were 13 separate applications for .app. There were 4 applications for .pizza. In the legal space, there were 9 applications for .law, .lawyer, and .attorney total. How will these applications for the same and similar names be worked out?
If the applications are for the same string, if they're identical, then they will be handled together in the same batch. If one applicant for .law had made it into the first batch, they'll all be handled in the same batch. So what will happen is they will all be evaluated and there will be objections raised. Assuming that some or all of the applicants pass through those stages, ultimately what happens is it goes into an auction. ICANN will say, we encourage the applicants to decide amongst themselves how to put forward a single application or how to compromise. And if a compromise cannot be reached and it's totally in the purview of the applicants to do that or not, it then goes to auction.
If an applicant gets knocked out, is there a refund?
If an application is ultimately rejected and not because of a withdrawal, then no, an applicant does not receive their money back. And for instance, this period, the closing of the window on this reveal date kicks off a time where governments can raise what they're calling an early warning that they may have that a particular application raises certain sensitivities within a particular country. A government can raise an early warning through the Government Advisory Committee within ICANN, the GAC, the Government Advisory Committee. Once that early warning is noted, an applicant can withdraw its application and get a substantial refund.
What would be something that might knock an applicant out?
ICANN is not in the business of giving these what in essence turn out to be licenses to run pieces of the internet. They're not in the business of giving these out to corporations that they feel like are not stable and are not in this for the long haul. And so they have asked a number of financial-based questions to make sure that the applicants are qualified and able to run the registry. So an applicant who perhaps didn't have its financial ducks in order and was applying could get knocked out because they don't have the financial wherewithal, and ICANN is not willing to take a risk on their application.
So if all 4 of the, for instance, .pizza applicants move on to the next round, what do we know about how ICANN will be able to encourage settlement?
They will let the parties speak amongst themselves to decide if there's a resolution that can come into play. ICANN has said publicly that they are in favor of the applicants working it out themselves so that it's not forced to go into auction. But there isn't a mechanism for ICANN to force it. I mean, ultimately, if it goes into auction, that money will be going to ICANN.
And how much do we know about the auction process?
It's impossible to predict how much it can bring in for ICANN. ICANN has already made upwards of $350 million over this application period. There are financial incentives, obviously, for certain corporations to make deals and maybe not go to auction. And then there may be other instances where there are incentives to say, no, let's go through this long haul. We want to go to auction. And there aren't parameters around that, what that auction will look like. So potentially some of the bigger players who have substantial financial wherewithal, they're going to get to choose how much they're willing to spend at auction if they're interested in going into auction.
Tell me about the batch process.
The fundamental challenge that ICANN had was this. They could only deal with so many applications at one time. At least that's what they said. And they said they determined that number to be somewhere around 500 applications, give or take. And so if the number of applications exceeded 500, they were going to have to determine some system to put in place to allow for applicants to go in batches so they can move the process along. ICANN said publicly that they had to be concerned about issues regarding running a lottery, and so they couldn't make it totally by chance. And so what the ICANN staff came up with was something that is called digital archery, and it is a unique process in which they are requiring applicants to go into their system and pick a time that they are going to then try to match by a click of a mouse. So, for instance, you go in and you pick a time of 3 p.m. today, and then at 3 p.m. you click on the mouse, and depending on how close you get to that actual timestamp, that will put you ranked in order. And ICANN will use that order to determine who's in what batch. The commentators have said, there are true challenges with that because some people are closer to servers than others, and although you're promoting it as somewhat skill-based, it really lends itself to true insiders or applicants who are filing for more than one application, I should say. And there are challenges with that. And so there are a number of major players who are unhappy with this digital archery process. There were a number of questions raised to an ICANN board member today regarding the digital archery process and whether ICANN was going to stick with it or choose to go in another direction. And he seemed to equivocate a bit and said that they're sticking with digital archery, but that they are going to be considering it at the upcoming ICANN meeting in Prague. And so that will be to be determined.
Processing in different batches will give advantages to earlier processed applications. Is that correct?
Well, there are potential advantages to it. In part, if you are first to market and you have a plan in place, then you're getting to sell names to the public sooner than someone in a later batch. So there are potential advantages. There are some disadvantages. There are some people who think, we want to see how this plays out. Does the public adopt these new TLDs? Do they become part of the public consciousness? And we'll let the people in the first batch be the guinea pigs for that, and then we'll sort of tag along and come next. So it really cuts both ways.
ICANN has earmarked $120 million in a risk contingency fund. What types of litigation should we expect, and who will the parties be?
That is a big number, isn't it? What types of litigation that we are going to expect, it's a little bit hard to predict exactly. Certainly you can imagine there will be some applicants who are unhappy with how they're being treated, especially considering ICANN seems to be continuing to change the process as even the process unfolds. There will be brand owners who are unhappy with the process, maybe at some certain level, and so they consider bringing some sort of legal challenge. There are always going to be, when ICANN's involved, antitrust concerns and things of that nature. So really, they've clearly stockpiled enough funds to deal with challenges that are really going to span the gamut. They've included a significant waiver in the application process, but they obviously understand that there are limitations to those waivers, and they're preparing for the worst, clearly.
ICANN has been criticized for how this process has gone so far. One writer called it a bug-plagued mess. There's even a Hitler Reacts video about the ICANN application process, and it has over 3,000 views. The Financial Times published an op-ed that said ICANN is about to get it deeply wrong. Tell me about what's happened so far, and are you concerned about ICANN's ability to pull this off in a fair and timely manner?
ICANN is in a difficult position. Having said that, they don't always help themselves out with how they've chosen to proceed in some instances. They rolled out this application process in a very unique manner in which they set up a system, a unique software system that all the applicants had to place their applications into. And so ICANN had immediate problems even with receiving applications. And so the window was supposed to close in April, and they found what in their terminology was a glitch in their software system. And because of that glitch, they had to pause this application process for, I think it's approximately 40 days. And so the window then closed on May 30th instead of in April. ICANN is a unique institution, and because of that, they choose to go at challenges in a unique way, and because of that, they are oftentimes out on a ledge with certain of their policies, and they generally, at least say publicly, they try to stick to those policies and processes, but things are always bumping up in the road. And so do I think that this will come about in a timely manner? Only time is going to tell, frankly, whether they're able to pull it off. They clearly have their detractors out there, and there are a number of applicants who are already unhappy with ICANN. That isn't to say that they can't get on the right track, but it is to say that it's going to be a difficult hill to climb, and all observers will be keen to look to see whether ICANN is living up to its sort of public mandate or whether it's falling down on the job.
ICANN said that the new top-level domains would be available in first quarter of 2013. Is that a realistic timetable?
That is what ICANN is publicly saying right now. Anyone who provides commentary vis-a-vis ICANN will tell you that ICANN rarely meets its deadlines. And that can easily be observed by even the reveal date, which was today. If someone was paying attention, they would notice that it wasn't a deadline of today for the real date, it was a target day. And they specifically chose target day because ICANN, dealing with so many different constituencies and bumps in the road that sometimes they know are coming and sometimes don't see, impact their timelines. So would I guarantee for anyone that it will be the first quarter of 2013? No, I would not. Although, do I think that they are going to be spending all the time and energy and resources they can to try to hit that timeline? I think that they absolutely will be doing that because I think the world is now watching them. But only time will tell whether they're able to do that.
Finally, I didn't see any law firms on the list. Your firm, Crowell and Moring, didn't apply. Why weren't law firms interested in applying for their own names?
That's a difficult question, and I can't speak for Crowell and Moring for myself, but I can tell you that a number of different considerations went into whether a corporation applies for their own TLD or not. And so, generally, companies like law firms, et cetera, who are more risk-averse are not true entrepreneurs in some sense of selling a particular type of product may want to wait until later rounds. So I did notice that there, at least it appears to me, that there aren't law firms who have been applicants, although if we dug deeper, I'm sure that there are some lawyers behind some of the .law or .lawyer applications. I'm not surprised that a law firm itself hasn't applied because generally they tend to be risk-averse.
That's John Murino, an attorney at the law firm Crowell and Moring. For more information about this and other topics, subscribe to BloombergLaw.com. You can find our recent programs on our YouTube channel. Follow my daily updates on Twitter at JoshBlock560.
Copyright 2012 Bloomberg Finance LP, all rights reserved. The views expressed herein are those of the speakers and not of Bloomberg Finance LP. These discussions are for informational purposes only and should not be construed as legal advice, which has to be addressed to particular facts and circumstances involved in any given situation. Bloomberg Finance LP and its affiliated entities do not take any responsibility for the content contained herein and do not make any representation or warranty as to its completeness or accuracy.